Welcome back to our series of podcasts in orientation for the University of Ottawa's JD program. In this podcast, I discuss the issue of reading cases with Professor Jennifer Chandler. How does one read these core sources of law? Why are they important? What are some of their key components and features? I began by asking Professor Chandler a little bit about her teaching and career.
I'm Jennifer Chandler. I have been teaching here at the university just over 10 years. My background before law was in the biosciences and biochemistry. I studied law at Queen's in France at Lyon and graduate studies at Harvard. I clerked for Justice John Sapinka at the Supreme Court of Canada and then practiced law for a couple of years with Stikeman Elliott before starting to teach at the University of Ottawa.
Great, wonderful. And so we're going to talk about why and how to read a case. So why don't we start by describing what a case is and why you would want to read it and why is it important?
Sure, yeah. Well, let's start with what is a case? Well, cases can be described in different ways, but essentially they are the written reasons for the decision of a particular judge, court, or tribunal. Some people describe cases as fables. In essence, what they're telling you there is that they're stories that contain a moral. So you get the who, what, where, when, sometimes the why, in other words, the facts of this story, but you also get a rule or a moral that comes along. And you also see how the rules applied in a particular situation, namely those facts. The cases are important, and they're something you start out with at the outset in law school. They are, I think it's fair to describe them as the lifeblood of the common law method. So the common law, which you might have heard about in a preceding podcast or one of the other podcasts, the common law system builds up legal rules through the use of cases and through looking at precedent cases and turning to apply them in a new situations or current situations. And over centuries, judges in the common law system have turned to these precedents to find rules that they then apply, they adapt, or else they reject as inapplicable in new situations. Now, if the legislature, which is another source of law in our system, not just the courts and their precedences, but also the legislature with statute law or written law. If the legislature doesn't like what judges are doing in their cases, they can write a statute, basically saying, judges, courts, this is now what the law is to be. But the story's not over because those statutes have to be interpreted and applied. And so the judges will get another try when they start to use the common law method again to build up the cases to show how that new statute is to be applied. So you can see there an interesting dance between the legislature and the judges over time, refining, elaborating rules, adapting them, modifying them, or even overturning them. This is something that you will learn about as you study not just the common law method in traditional common law courses, but also courses that are statute-based. Now, still on the subject of what is a case, let me tell you a little bit about what are the advantages of having cases. Well, as I've already suggested, one of the advantages to having written recorded reasons is that they serve a record for future use, so that judges can go back into them to find precedents and apply them. But there's another layer of utility that these cases have. If you think about it, they force the judge to provide a clear, defensible explanation for the decision. And so rather than just declaring who wins and who loses, the judge has to sit down, think about it, explain in a persuasive manner why. So this provides some degree of transparency in the reasoning, and it also, to some extent, constrains arbitrariness in the decision-making. It also provides a written record that the parties, if they don't like the outcome, can then use as a target for appeal. So think about it. After all, if you have a black box, some process produces the final decision, it's harder to critique it. It's easier if you have the reasoning, the steps in the reasoning outlined. Parties can then go back and point to what they think was wrong. So these written judgments provide some consistency and predictability by furnishing a clear record for subsequent judges and lawyers, but it only goes so far. I think you're going to find when you start to read cases and study cases that many legal rules are incredibly vague. So, for example, when you're studying negligence law, you'll learn that the rule in negligence is that there's a duty to take reasonable steps to avoid causing foreseeable harm to others. So this is kind of a strange rule. What's reasonable? What's foreseeable? Well, it would seem that a rule that you must behave reasonably doesn't offer much by way of consistency, predictability, and constraint on arbitrariness. But the reason I'm telling you this is to show you a key tension at the heart of the law in general, namely that between predictability and specificity on the one hand in rules, and between flexibility and efficiency on the other. So if we think about it, if we had to be completely predictable, completely specific with our rules, you'd be in law school forever, reading like mad all of the rules we've articulated to govern every possible situation. So we need more general rules. Furthermore, situations are different, so a bit of flexibility is needed so that just outcomes can be achieved, and times also change. But all of this flexibility and adaptability puts at risk the countervailing desire we have for ensuring consistency, that there's no unfair inconsistency between like cases. So you're going to see this tension over and over again as you learn to extract the general underlying rules from specific cases and specific fact situations, and figure out at what level of generality to articulate them. And you're also going to learn this as you learn to work with those rules, how to apply them, how to take those general rules and to argue about how they should be applied in specific new fact patterns. This tension between flexibility and efficiency on the one hand, predictability and specificity on the other, will be something that you'll see and have to navigate in learning to take rules out of cases. So that's a little bit about what is a case. How about where are these cases? Well, the history of written judgments is a very interesting one in the common law tradition. How did these cases end up getting recorded anyway and spread around so that judges and lawyers could use them, follow them, apply them? Well, there's a history to this, and the kinds of written judgments that we see now and that you're going to be reading very shortly, we see them recorded in their current form, or reported, as we say. They started to be recorded in this way in England in the 16th century. And this typically at that time involved private parties starting up a bit of a commercial enterprise by going to court, sitting there, and transcribing the oral or spoken reasons of the judges. So in some of the older cases you read, you will see, you will detect that it's a record of a spoken judgment. Sometimes in the old English system, there will be various judgments rendered, and they're called speeches. This reflects that tradition. Courts then later took to issuing their own reports, and today much of this has now moved into electronic form. Although you will see reference to a multitude of commercial reporters. These are services that record, publish judgments. So you'll see reference to lots of commercial as well as court-issued reporters.
That's great. So how does one deal with the case? You encounter a case for the first time, you open it. What's the kind of thing you would see? How do you go about reading it to understand it?
Yeah, sure. I think just before I move into that question, let me separate your question into two. There is, first of all, the question of what are the basic mechanics of understanding a case? What is its structure? How's it written? How do we know what part is where and understand it? There's also, I think, another question which is implicit into how to read a case, and that's also why. What is it you're trying to get out of the case? That's going to affect how you read a case. So let me start with the basic mechanics. Most published cases now follow a standard organization. You'll have basic information near the top, essentially the name of the case. Jones versus Smith, for example. Often, but not always, the name of the case will be the names of the opposing parties in the dispute, and you'll see there's a variety of other cases, name types that you'll encounter. Also at the top, you'll see the year, the court, which court heard it, the name of the judge, the reporter, where do you find this case? Often there can be many locations that it's recorded. After that, sometimes, not always, there will be a short abstract of the judgment. It's called the headnote, and sometimes a set of keywords. Now, the keywords in headnote are not part of the judgment, and you shouldn't treat them as the law. They're there just to help you. It's a synopsis that helps you to find out basically what's this case all about. They should not be quoted as law because they're not law, they're meant just as an aid. Now, sometimes the judgment will then go on to list the sources of the legal rules that the court will later use, so a list of statutes and cases that are mentioned in the judgment to come. Then, after all of this, we launch really into the heart of the matter. Sometimes there will be one judgment. In a court where there's numerous judges hearing one dispute, you might have a variety of judgments. But within each judgment, there's some variation, but typically you'll get a history of the case, what happened in earlier proceedings. If, for example, this is an appeal, what happened at the trial level. Then you get into a list of the facts, the who, what, when, where, why that I mentioned. Then typically a summary of the legal rules the judges propose to apply, and then the application. After all of that, there's a decision, and this typically involves a discussion of remedies. What resolution is the court going to order? Is so-and-so going to pay money to the other? Is there going to be a rule that a party must cease and desist from some activity? Does someone go to jail? The outcome typically is explained at the end as well. First-year law students are usually very, very keen to learn how to prepare what's called a case brief. You might have heard of this. In essence, what this is a short summary of a case that you will prepare after reading the case. Your professors will usually recommend certain set elements and a structure for a case brief. The objective is to summarize the case into a short, well-organized, easily understood format that provides a brief snapshot of a case that can be quickly reviewed later, a set of structured notes that helps you to ensure you thoroughly understand the case and helps you to record that understanding. Now, I always tell my students that it's very important not to get too hung up on the form. The important thing to note is there's no one way to do this. What you need to include in a case brief, what the elements are and the approach you take, depends ultimately on what the purpose of the brief is. So by all means, follow the directions that you're given as you start out on learning how to do this, but keep an eye out for what you find actually useful for the given purpose that you have in mind for the case brief. So this brings me to my last question of why do you read cases? So I've already hinted at this at the outset. The common law system relies on it. That's where you find an important source of the law in a common law system. But also, as I mentioned, this is meant to produce a measure of consistency and predictability and constrain arbitrariness. So in essence, to know the law in a common law system is to know how to extract the rules from a whole set of cases, how to put them together to explain the structure of a rule, extracting it from all the very specific little cases in which it's applied to understand the underlying rule. And then to use the law in a common law system is to know how to take these underlying rules to figure out whether and how they should apply in new situations. All this being said, I don't want to leave you with the impression this is a thoroughly objective, determinate, or even fully logical process. As you start to go about doing this by reading cases and extracting rules, you'll see that the process of extracting the rules and then applying them is highly creative. The rules themselves are often messy compromises between incompatible objectives. And this may sound a bit frustrating, but really this is why you're in law school. There is often much room for good lawyers about what the legal rules are and how they should actually apply. And that's, I think, what you will start to find quite fun as you learn to dig through the cases to understand them and find the rules.
It's wonderful. Can I ask a little bit about the components of a case so that people understand terminology?
Mm-hmm.
And so you've mentioned that there could be at the beginning of every case, or there should be at the beginning of every case, a name. Are there some guides you would have on how you decide whether it's a civil case versus a criminal case that you can discern from that name?
Certainly, yeah. So criminal cases will typically say R versus Jones. The R is a short form for Regina or Rex, the Queen, or the King, depending upon the time of the case. And the reason for calling the case that is that in our system of criminal law, the dispute is understood as one between the Crown and the individual, between the state and the individual. And that's why the antagonistic parties in a criminal case are Queen versus the accused person. Whereas in civil law, you not always, but very often will have two private parties who are disputing, and you'll see their names.
And what about instances when you have several judges? So this would be an appellate court. What do you mean? We mean by the concept of a majority opinion versus a minority opinion?
Right. So when you're, for example, at a provincial appeal court, cases are often heard by 3 judges, and at the Supreme Court by 5, 7, or 9 judges. You can see these are odd numbers for good reason. You want to make sure there is a majority and a minority if there's a dispute. So sometimes, if the judges on a panel disagree, there will be several judgments written, and a number of judges will sign up to individual judgments. And the ideal is to have one judgment that attracts a clear majority. And this will then be understood as the articulation of the law to use going forward. Sometimes it can get a bit messy if you have a case at the Supreme Court, for example, that has 2, 2, and 1, which is then the majority. Or sometimes, as sometimes happens, you will get judgments in which different numbers of judges agree on different points, and you have to really get out your graph paper to figure out what the law is on any one given point.
And so you can have a majority, you can have a minority. The minority could be a dissent,
right?
In the sense that they are opposed to the outcome being voiced by the majority. And then you can have concurring opinions. And so a concurring opinion would be...
A concurring opinion is where two judgments are rendered to explain why you get to the same outcome. The judges agree in the outcome, but they disagree on how to get there.
So the reasoning might be quite different, even though the outcome is the same.
Exactly.
And so you're left wondering what the actual precedent is for that particular area of the law.
That's right. If you don't have a majority, say 3 judges on one and then 2 on a concurring, if you don't have that, you can't determine which is going to be the guiding rule that emerges from the case.
Do you have other advice for students on how to read a case?
I would say it's often advisable to skim through a case quickly from beginning to end to get a sense of where different bits of information are placed, and then to return again to the beginning with a sense of the overall structure in mind. It can save you time in the end. One thing you'll also find, and I certainly remember from law school when I started to read cases, is that at the outset it was incredibly slow because I wasn't quite sure yet how to determine what were the most important parts of the case. I think this is something that you learn with experience, so not to get too despondent if you're finding that the reading is slow at the outset. This is a skill that you develop and strengthen over time.
I want to ask you, while I have you, about an area of speciality that you work on in the law school, and that is on the area of medicine and law.
Right, yeah. This is something I'm very excited about and committed to. We have here at the law school, we're very lucky to have a growing group of really interesting faculty members looking at different aspects of health, biosciences, and the law. A whole range of different topics, from the constitutional human rights aspects of access to law, public health law, the private law aspects of medical malpractice, the regulation of health professions, and more, bioethics and so forth. My particular area of focus for my teaching is in the area, the legal issues that emerge from the advances in the sciences of the mind. So this might be the cognitive neurosciences, the behavioral genetics, and it's very interesting to see how these are being incorporated into legal doctrine, into how we address criminal offending and so forth. I also do quite a bit of work in selected areas of medical practice, the ethics and law of them, such as organ donation, transplantation, and regenerative medicine. One of the topics there, for example, is how we decide when and whether we should restrict scientific inquiry, for example. So these are interesting philosophical and legal questions that affect health and well-being and scientific freedom, for example.
Wonderful. Thank you very much, Jennifer.
Sure. It's a pleasure.